Okay. All right. And I see we have our presenters for our next topic. We have Justice Montoya Lewis and Seattle University Law School Dean Tony Verona. So welcome. And I will just turn it over to you.
Thank you, everyone. I'm glad to be here and had a brief conversation with Dean Verona just a little bit ago. So I'm going to go ahead and get us started, and he's going to jump in as we proceed. And I understand that you have the documents that we provided that are the documents that are going to be going out and presented to the Supreme Court, as well as presented to the public over the next month or so. So really what I'd like to do, rather than go line by line through these documents, is just give you a little bit of a history. I know we've presented in front of the Board of Governors a couple of times, but just to kind of review that, and then talk very briefly about what our recommendations are going to be, the process that we intend to undertake in terms of presenting those recommendations, and what the court's plans will be in terms of what they're going to do with those recommendations. So that'll be kind of my presentation, but I do want to just encourage you to ask me any questions along the way. I'm happy to invite those questions. If you're ready to move to questions quickly, that's fine with me. Both Dean Verona and I are very happy to take those questions. So as I'm sure you recall from prior meetings and discussions that we've had with you, the Washington, Bar Licensure Task Force was formed by the Washington State Supreme Court after the July 2020 bar exam was canceled, and the court adopted diploma privilege for some of those examinees, and then other processes moving forward just for that July 2020 exam as a result of the COVID crisis. As a result of those many conversations that the court had internally as well as externally, the court founded this task force. I am the co-chair of that task force. We have the mission itself laid out who was invited to be members of the task force, so that we had a significant cross-section of people from the bar and representatives from the Board of Governors, as you're aware, all of the law schools, and multiple practitioners, individuals from other parts of the Board of Governors, committees, and we have been having meetings on a monthly basis since about, I believe we started October 2020. So as we've proceeded through those meetings, initially we established a number of committees to look at a variety of things. But beginning with, and what I will begin with is just a kind of some of the foundational questions that we started with when we started moving towards developing alternative recommendations to the bar exam. And the first question really was, should there be alternatives? Should we be recommending alternatives? Are we happy with the way that the bar exam is going as it is at this time? I just caught the tail end of that conversation about the next gen bar exam, but we also heard from the NCBE about what their anticipated changes would be moving forward when with the next gen bar exam. So we looked at that question, and as part of that, we also heard from Dean Howarth, who I also think you have heard from. But if not, I know that you've been given the information about her book, which talks about the history of the bar exam, and largely that history is unfortunate is probably the best word I can choose. But we've also we spent a lot of time just learning about the history of the bar exam and its adoption, not just in Washington, but across the country. I think the main thing that I want you to hear about what we concluded in terms of where we are with the bar exam is that I think, as you know, Oregon is adopting alternative pathways. There are some other states that have alternative pathways already, Wisconsin being one of them. But this conversation about alternative pathways is one that's happening at a national level with the NCBE as well as with law schools, and absolutely with incoming law students who are very concerned about the equity issues that are evident, not just in the history of the adoption of the bar exam, but also over the course of many decades when you look at the disproportionate impact that the bar exam has on examinees of color in particular, who tend to fail the bar exam in disproportionate numbers, and in numbers that are reflective of the problems that exist with standardized testing kind of across the board of all standardized testing. Sorry. What I want you to hear from us today is that what we are trying to do with these alternatives to the bar exam is to continue our status in Washington as one of the leaders in both legal education, the development of the law in all kinds of areas, the development of our approaches to the courtroom in terms of equity. We're really hoping, I think, in the task force, and I certainly am not in a position to speak for the entirety of the court, but I think I can really represent from the task force that we're really hoping to continue to be a leader across as an example of what we can do with alternatives to admission and what that can look like. So I'm very excited about the alternatives that we're going to present today, and hope that you'll have some questions for us. I think the only other thing I'll say before I just jump into these alternatives is that there was a tremendous amount of research that went in to each of these alternatives. This committee presenting on that did a tremendous amount of the work leading into the alternatives that were presented to the task force as a whole and then adopted by the task force at a retreat earlier this year, was led by Jordan Couch, and I really want to thank him for the tremendous work that he did, and the work that the committee did in terms of looking at alternatives that are ones that exist in other places, like diploma privilege, and then those that are new in this what our recommendations are going to be. So I just really want to thank him for the tremendous amount of work that went into that. So what I will just start with is that as we move forward, we're going to recommend that we continue to have the uniform bar exam, or the next gen bar exam, which it appears it will be called as it moves into its new iteration over the next couple of years. Is that we think that should be a pathway to licensure. The recommendations that we have is that should continue to be a pathway, but not the only pathway. So we are intending to recommend to the court that we maintain the uniform bar exam as a pathway, in part because that number can be a pathway towards reciprocity in other states, and is something that we've heard from examinees and potential bar takers that may be that is an important pathway for them for a variety of reasons. It's also useful because we already have the pre-existing reciprocity rule in the state of Washington that will allow people to come in from other states if they've taken the uniform bar exam. So we are going to recommend to the court that we maintain that as one pathway to the bar exam. Excuse me, to licensure. Let's see. So, as a part of that recommendation, there was a lot of discussion about what the next gen bar exam is going to look like and why that might be a more reliable tool in terms of assessing whether someone's prepared to be admitted to the bar exam. But we also, as I said, looked at the history of what the bar exam was doing in terms of testing and what it was measuring, and considered both what it was actually doing as well as what the intention was of having a method by which we would measure competence to practice. And in doing so, we then moved forward to looking at what alternatives we would recommend that would continue to ensure that people that started to practice in the state of Washington would be competent to represent clients. So that was really one of our driving forces, was ensuring that we had some manner in which we could be certain that people who came into the practice of law were doing so with a basic level of competence, and in so doing, that the public that they represented would be protected. Those were two of the things that were driving our analysis of alternatives as we considered what all of those alternatives would be. One of the questions that came up as we discussed extensively was, what about diploma privilege? As I said before, the court gave diploma privilege to graduates of law schools, and that was just for that one test, July of 2020, and as I said, it was a result of the COVID crisis. There were lots of discussions at that time about not just by the court, but by law students, by potential examinees, by people who are in the Rule 6 program, a number of conversations with individuals from each of those groups. And I'll just also let you know that we heard from all of those groups, as well as members of the public, extensively, as with letters that went directly to the court, that were addressed to all 9 of the justices. And then many of those letters, and I would say that I would say it's by a supermajority, those individuals were encouraging the court to make diploma privilege a permanent thing in the state of Washington. We also heard objections to that recommendation as well, we received hundreds of letters. And so, as I said, they were largely in favor of that, but there were also many people raising concerns about that. That would be an easy approach, I think, to recommend to the court that there be some form of diploma privilege. But after a lot of discussion, and in particular discussions with Dean Howard, who wrote the book I referenced earlier, she gave a presentation a few months ago to the justices at one of our en banc meetings. And that was really one of the questions that several of the justices have. Why not diploma privilege? And she said, pretty frankly, to the justices, I've heard her say this in other much larger meetings, and she said it to the task force, and that she wasn't confident that the law school, she wasn't referring to the 3 in the state of Washington, but across the country, really weren't prepared in their curriculum in her mind, for her to confidently say anyone with a diploma from those schools is ready to practice. And she said, I've been a dean at multiple at law schools. I've been a professor at multiple law schools. I don't think we can say that across the board and that we're ready to do so. And I thought that was an important thing, and I wanted to just mention that. So that is not something that we're recommending as a task force to the court. We spent, as I said, a lot of time discussing it and looking at that as a possibility, and ultimately decided not to make that recommendation. The first alternative pathway that we're going to recommend to the court is the adoption of an apprenticeship program. And that is similar in some respects to some of the aspects of APR 6. Sorry, I have a kitten here who's trying to get my attention. We've drawn on those tutoring and licensing requirements that already exist in APR 6 and also in APR 9 to develop this recommendation. And so this recommendation would be for law school graduates who can complete a 6-month program that would ultimately, once they were completed with that program, would then result in them being able to be licensed absent the bar exam. This is a substitute for taking the bar exam. I think I will just leave it at that, since I understand that you have these documents and imagine that you've read through them. The second alternative that we're going to be recommending, in addition to the apprenticeship program, is the law school experiential pathway. And this is going to be a pathway that that the law schools, I hope, will be in supportive, and Dean Verona can talk somewhat about that, because he's been talking to the deans, and I understand that you met with them yesterday about this potential pathway. This is an approach that's been used in other states, and that will allow students in law school to take a set of classes, as well as to let me back up, to take a set of classes that are skills-based, so that once they have completed that set of classes, they'll be in a position to have learned how to talk to clients, how to represent clients, and how to do those things that we assess as critical to being a competent practicing attorney, as well as taking classes that are substantive in nature in addition to skills based courses. And so so effectively what this requires is 12 credits of skills-based classes, the rest of their law school program, however that is defined in the law school that they're in, as well as 500 hours of work experience that would provide the experience necessary to be ready to go into practice. That could be done through clinics. I am well aware that not all the law schools have the faculty to support every law student doing this through a clinic. That's not our expectation. It's just one way. Students could also be doing that through employment, and I think also potentially through externships. The other recommendation we will have is the APR 6 program, which we would also be recommending as another alternative pathway to complete all of the coursework effectively that the rule already has, and then allowing them to be licensed to practice once that they've completed that set of classes that are laid out, without taking the bar exam, but by requiring them to continue to have the same 500 hours that the law school experiential pathway would also require. One of the things that I think is really critical to our recommendations is that we are going to be recommending to the court that we also, if the court adopts changes to and adopts one or all of these pathways, that we also engage in the process of studying what it looks like for a cohort of individuals who are licensed to practice through taking the bar exam, and against the cohort of students of licensees who became licensed through one of these alternative pathways. I think it's really important that we look at that we use this opportunity to study each of these groups and then look at what that means in terms of complaints to the bar exam. There's going to be, in order to develop the study, this is sort of going to take another proposal, working with researchers to develop what this will look like. We've only had some very brief conversations about how to develop a study like this. It will require funding, but what we really think is important is that we take an opportunity, if we do move forward with alternatives, to study the differences, if there are any, with regard to any kinds of malpractice claims, disciplinary claims, that complaints, how those may or may not get resolved by disciplinary counsel. We also recognize that those are not necessarily the greatest measure of competence or what's actually happening out in the practice, and that's why we really have to do some work to develop what that research tool would look like. But this is a real opportunity to study that, and so we're going to be recommending recommending to the court that there a study be developed and funded so that we can move forward with really looking at, are there differences based upon this different ways of becoming licensed as a lawyer in the state of Washington. We also are recommending some changes to the reciprocity law, reciprocity rule, and I'll just note that that's laid out in your document. There's also an additional set of recommendations about character and fitness and what that looks like moving forward. That was another committee of the task force. You also have that document. I have talked a long time at this point, and so I'm going to stop here and we'll come back to that character and fitness. I'm mindful of the time, and I want to make sure that everyone has an opportunity to ask questions as they have them. If we need to come back to talk about the character and fitness recommendations in more detail, then I'm happy to do that as well. But I want to make sure that there's some opportunity for people to ask questions. Dean Verona, do you have anything you want to say before we open it up for questions?
No, I think Justice Montoya Lewis has done an outstanding job of giving you all the overview of our work. She's been co-chair from the start, and we had a number of successive co-chair changes. I've only been co-chair since July of 2022. And we should mention also that Governor Brent Williams-Ruth did a spectacular job of filling the gap as a de facto co-chair when we needed his leadership the most. And so we owe him a big debt of gratitude, not just for those periods of time, but he's been a very effective committee chair and has kept the trains on time and moving. And so we thank him too. The only other thing that I would add to what the justice has shared with you is that there's been a lot of conversation, not just in this community, but also in our meetings around protection of the public. This is something when I was briefing the Western District of Washington federal judges as a Meet the New Dean lunch special guest. This is what they wanted to talk about. After I had talked to them about my vision for the law school and mentioned that I was a co-chair of this task force with Justice Montoya Lewis, a number of them raised this concern about protecting the public, which is obviously front and center to our work. And exactly as Justice Montoya Lewis said, we talked a lot about it during our various deliberations on the alternatives. And I think what's important to understand is that study after study has shown, and Dean Howarth's book, wonderful book, documents in an abundant manner how the traditional bar exam is not a good instrument at protecting the public for many different reasons. It has been deeply problematic. And as a legal educator and a law school dean, I have seen again and again and again how some of our strongest students academically fail the bar at their first attempt for no good or reasonable reason. And so even if you come at it from that way, it is a problematic instrument. And then add the much more serious problem of the documented bias that we have seen with the traditional bar exam. The alternatives are long overdue. And the other thing that's important to keep in mind is that we will be looking at the effectiveness of the alternatives, assuming or presuming, of course, that the Supreme Court adopts them, to make sure that we have gotten it right. And to the extent that we need to make any early implementation corrections, then we will, or the court will do that at that time. So I just wanted to add those additional thoughts to Justice Montoya Lewis's excellent overview.
Thank you.
Any questions, comments, recommendations, reactions? I know that we talked some yesterday about these topics.
Sorry, I'm not on Zoom, but this is Eric Kading, District 8 Governor. Question for you. I mean, I'm not entirely familiar with the details of all of the programs, obviously, that are going to be presented. But my understanding is that one of the programs is there will be a selection of courses that will be offered through the law schools, combined with, I'm hearing from this morning, 500 hours of experience that would be a substitute for the Bar Association. Is that right? I mean,
Governor, yes.
For the exam, I'm sorry.
Yes, that is one of the pathways. This is the law school experiential pathway option, which would essentially enable a student to obtain licensure by going through specific curricular offerings and actually completing successfully specific curricular offerings in the experiential realm. So every law school would be able to offer their own menu of experiential courses that would meet those requirements, but they could, as we noted in the document that we shared with you, they could be in skills categories having to do with mediation, trial practice, pretrial advocacy, negotiations, criminal motion practice, contract drafting, etc. And so we're thinking that if they took that kind of menu of courses, and they were essentially then for those particular students on that pathway mandatory, we would be doing several things. Number one, responding to what a lot of you have told us, that you feel that there's too much of, and I share this view, there's too much of a disconnect between practice and law school. And so this is one way of addressing that. But then the other more central purpose of that particular pathway is that it provides students an opportunity to show through the experiential offerings that they complete successfully that they are competent to practice law.
Okay. My question
Yes.
is, going through that program.
Yes, sir.
Who is the one that makes the ultimate decision of whether or not they're competent? Is that done by the law school, or is that done by some other person?
It would be done. That's a very good question. Thank you. It would be done by a combination of the law school professors grading them and then the law school certifying in the end that the student has met the requirements for that particular pathway.
I only mention that because I know a lot of people that I went to law school with were excellent in law school. They easily passed the bar and they were terrible lawyers. So, I just want to know who's making the determination, if it's a experienced lawyer or if it's an academic decision.
Yeah.
So
the only other thing that I would add, Governor, is that I cannot think of any experiential law school professor who would be teaching these courses who do not already hold a bar license and are successful practitioners in their own right.
Thank you.
I just want to note, I see a couple of hands on Zoom, so I'm going to call on them, but I can't see very easily who's got hands up in the room. So if someone can help me with that.
I think Governor
helpful.
Sayani has her hand up. Yeah.
Yes. So go ahead, Governor. Thank you.
Thank you. Thank you for your presentation. I guess one of the things that I am concerned about with a hybrid approach is the impact it's going to have on students' ability as an equalizer to get jobs in law firms. And then in addition to that, potentially an inequity in pay between students who choose to go directly into an apprenticeship program versus those who have received the license through the traditional bar exam. So, how are we getting statistics or addressing, the ability of law firms to buy into this, buy into a program away from the traditional looking at a law student saying, okay, you passed the bar, that's good enough. And by the way, I don't say that I believe that's good enough for competence. Obviously, I think the apprenticeship program is more important and a better gauge of a lawyer's ability to practice law over time. And I liken this to the Canadian legal system,
Yes.
has the articling.
Yes.
They have an articling component for all law students, and then a
Exactly.
requirement that they take the applicable provincial bar after a year of articling.
That's right.
So I don't know if maybe the hybrid was an attempt to start moving things in a certain direction without offending the fact that there's this institution in place, or what that was. But I guess, yeah, I just worry about how, law firms are going to react to treating candidates equally, given that there is an unequal way of getting licensing.
Yeah. Justice?
Yeah, that's an excellent question. We have discussed this at length in the course of developing these proposals, and discussed them at length in a variety of meetings. I think you are accurate that there is going to be a process of educating the law firms, as well as the public, on what these alternatives are, why they exist, and what that looks like, versus the bar exam, and why there shouldn't be a difference in hiring and so forth. That's going to be, I think, part of the discussion, and, for want of a better word, the marketing of this. That said, there is going to be a difference. When we did diploma privilege, we heard from examinees who said that their offers for jobs, mostly from law firms, were contingent on them taking the bar exam and passing the bar exam, even if they were licensed under diploma privilege. So that, I think, is going to continue to be an issue, and as we move forward. And I'm not really sure how to completely overcome that without there just being consistent, open discussions with the law firms and the public and anyone else who has concerns about this question. I will say, I was a trial court judge, for 20 years before I came on to the Supreme Court bench. And one of the things I said to students was, if they were worried about whether or not they could be a lawyer, all they needed to do was to come in and sit in my courtroom for an afternoon and see that the range of practice skill is all over the map. And, we have outstanding lawyers. We have lawyers who are less than outstanding. And I think you all know that, because you've all seen it, and we've already heard reference to that. And I think that that's a conversation that we just need to have more frankly. And I will also say that I have had phenomenal externs and others who have worked for me over the years, who have struggled to pass the bar exam. I have had people who have been the best students I've ever had who struggled to pass the bar exam. And just as Dean Verona was suggesting, for no good reason. Some of that, I think, is a conversation that is a bit siloed. It's a conversation that I think a lot of lawyers of color have and are very familiar with, but aren't really, the conversation isn't necessarily going beyond some of those groups. And I think we need to have those conversations, as I said, more openly and frankly, with the practice overall, and that's got to include some of the law firms. I think you're right. I think that there's going to be a struggle with some of those inequities that you're making reference to. But I think that can't be a reason not to do it. I think it's a reason to do it, and to continue to have these conversations about what the bar exam is testing and what that looks like in terms of perpetuating some of these inequities, and what that means in terms of our assumptions about competency.
One of the things that I would add, Governor Sayani, is that in our various deliberations on the task force, we have kept reminding ourselves that our mission is somewhat limited, and we are not going to be able to address every disparity and every unfairness. And unfortunately, a lot of disparities and a lot of unfairness will remain after we do the job that we need to do. But what we are trying to do is to minimize the disparity, minimize the unfairness, minimize the bias to the extent that we can. But I think you're absolutely right. We will collectively as a profession still have a lot of work to do. And the way that we implement these various proposals needs to be very mindful and very careful, not to worsen harm in any particular sectors, and to identify what it is that still needs to be done. So, Governor Fay, I think your hand was up next.
Actually, do you mind if I just add one more response?
Please.
That I think you two didn't cover, that I also think is important. And I think this really came out of Oregon's work, is that any one of these pathways is likely to have its own biases and piece in it. And so having multiple pathways in and of itself is one of the benefits, because some pathways will work better for others than.
That's exactly right. Tara is a member of our task force, and she's been just phenomenal. And you can see why and how. Governor Fay.
Thank you, Dean. I wanted to make one observation and then a question. On the observation is the experiential, the experience that one would get outside of the law school. Folks have made the allegory to articling as in Canada and the United Kingdom. I will point out that articling has been a terrific barrier to entry in many Anglo jurisdictions, primarily because they don't get paid, or they don't get paid very much. If you were going to require someone to work 500 hours for free, that is as steep a barrier as waiting, the time between graduation and taking the bar exam. Law firms who hire people expecting to pass a law exam, but you can start work before you know whether you're passed or not, and you'll get paid for that. I am concerned that this could be an avenue for exploitation of people who will be subject to that exploitation. And that is a concern. The other concern I had in reading the memo is that the law school plus 500 hours track would be available to people who have their degree from a non-accredited law school. And I am familiar with some California counsel who went to the storefront law schools who are not good lawyers. I will leave it at that. And it looks that particular branch means the quality of your legal education is irrelevant as long as you get your 5 hours in at some law firm somewhere. And that gives me grave concern.
Governor, thank you for pointing that out. My recollection was that we intended the law school pathway to apply to ABA accredited schools, but my fellow task force members and Justice Montoya Lewis can correct me. Maybe what we need to do is just clarify that in the proposal.
There's a specific FAQ that says non-accredited schools we're looked down upon, and we're going to go for it. And that I am very concerned about that.
All right. So that might be something that we will need to discuss again.
I can provide a little clarification on that from our conversations when this came up. And again, I think I mentioned this yesterday. Already, you could theoretically practice law in Washington from a non-accredited school. We, as the Board of Governors right now, control what schools are allowed to sit for the bar exam in Washington. Part of one big aspect of this entire proposal is using existing infrastructure in that. And so the question was, did we want to have a specific rule in this saying you have to be an ABA accredited law?
Oh, that's right. Now I remember the
task force want to say that, or did we, as the task force, want to say the WSBA already has a structure in place?
That's right.
And what schools are qualified and what gets to be part of that. We don't want to try to usurp that. We want to continue in the existing pathway. So we didn't want to put in a rule here.
That's right. That's right.
It has to be an ABA accredited law school. We put in a rule here that says this program, WSBA will continue to have the exact same control.
That's right.
Into entry into the profession. And one aspect of that also is that, we have the Washington schools that have the Rule 9 programs. Not other states do not have Rule 9. They have similar programs. So the determination of what constitutes a similar program such that it's sufficient to qualify for the Washington diploma, program would be also a task given to the state bar. So it's maintaining control, maintaining systems, not saying you don't have to go to an accredited law school. It's saying the state bar in its current process should decide that rather than us deciding that.
Jordan's absolutely right. We started with the proposition that they would need to be ABA accredited law schools, and then move to this other position precisely for the reasons given by Jordan. Jordan, thank you for the reminder. Governor Rathbone.
Thank you. I first want to say I appreciate the Rule 6 program being included in this alternative pathway. I am, again, for the permanent record, a Rule 6 graduate and proud of it. So I want to acknowledge that and thank the committee for including us in. I know diploma privilege can be somewhat offensive to us law clerks because we would not have been afforded that. Obviously, we don't have JDs. But I'm also from a rural practice area, so what I am asking myself as I read through the proposal is if the committee has put any consideration into providing additional incentives through this alternative means process for the legal desert areas, and if that's been a consideration. And then next, I think in looking at this, I would like to see if this is going to ultimately go before the Supreme Court, the mentor portion developed a little bit further. I guess one of my concerns in looking at this is I don't want it to be a pipeline into specific law firms. I think there has to be a level of equal opportunity from the law firm and mentor standpoint across the board. And so when we talk about mentors, yes, practicing actively for 10 years, no disciplinary actions for the last 5. Okay, and what? It leaves me with something to be desired, at least as far as mentors are concerned, because what I also, in thinking about that, fear is that these firms will take that as a means to provide a low-cost employee to their force and not provide the mentoring services that we're saying that these attorneys need to have to be able to survive in the practice of law. Yeah. So as I read through this, again, I appreciate the work of the committee, but those are just some things I would like to put out there also. And I think I asked a specific question, but now I'm not sure anymore. So
Governor, thank you very, very much. And as Justice Montoya Lewis referred to, we will be gathering a number of all of your comments and then having another meeting with our task force. This is an iterative process, in other words. And so what you are sharing with us is very, very helpful, very useful. We will be taking it back to the full task force and then refining these recommendations as we work with the Supreme Court and coming up with specific proposals. Let's see, Governor Angilvel.
Thank you. And I really want to thank the task force for the incredible job that it did. I am the product of a Canadian law school, and I was an articled clerk for 1 year, 1,000 years ago, in the 80s. And I have to say, I'm really intrigued by the idea of adopting this experiential component. But like Governor Rathbone, I'm a little concerned about equity in terms of pay rates for, graduates of law school and the potential for, frankly, labor exploitation. In Canada, all law firms and government agencies provide for their articled clerks, and you do get paid less, but it's kind of a standard across the board. You don't get paid a lot of money for the first 9 months after you graduate from law school. And and you do 3 months during a summer, your summer in between second and third year, or at least that's the way it was in the 1980s. I really like the idea of having that experiential component, but I really urge the task force to think about how we can encourage law firms and mentoring, whoever the mentoring folks are going to be, to be mindful of the financial situation of young graduates.
Thank you very much, Governor. And I will very briefly say that this very topic was the cause of a lot of conversation during our deliberations on the task force, and a number of our colleagues on the task force brought up the very good point that it takes resources and it takes time and it takes energy to be a supervisor for this bar licensure candidate, and that to expect all of those supervisors to then pay in every single instance where some of the supervisors would be practicing barred lawyers in small firms that would not ordinarily be able to afford to take on one of these pathway candidates would be just too much to ask for in terms of licensure regulation at this point. But this is an active conversation. We could certainly take back this topic. The other issue that was raised in our task force was that we certainly didn't want to foreclose small public interest law firms, small law firms that are minority owned, minority run, that wouldn't be able to afford a particular salary and have an existing relationship through an externship or other internship program with a student that would want to be supervised by them through this pathway. So we were trying to maximize flexibility, but what you raise are very, very good points. Governor Abell?
Well, thank you, Dean Verona, and thank you, Justice Montoya Lewis, for that wonderful presentation. Thank you for all the hard work that you've done. I appreciated Governor Sayani's comments and observations about concerns about the perceived bifurcation within the profession for individuals going through these alternatives. As I go about service in the coming year, I'm thinking a lot about building the public's trust and confidence in our profession, and I guess I'm thinking about how do we avoid a perceived public belief that there's a bifurcation of the profession. In other words, you've got the individuals who pass the bar, and then you've got everybody else. And that's something I'm trying to think about, how do we avoid that? And there was some reference a little bit earlier about the process of trying to build the public's trust and confidence in these proposed alternatives. I guess my question would be, what practically would that look like? Is this some sort of a concerted media effort to educate the public of Washington about these pathways and why they can have trust and confidence in their attorneys going through this process? I wonder if you could tell me a little bit more about that. Thank you.
That's a great question, President-elect Abell. I mean, this is something that we have started to discuss around how, once we get the Supreme Court's approval, how do we help the court roll out publicly these various pathways. I mean, I was just thinking a little while ago as we were speaking that maybe one way that we could help with public education is to have Justice Montoya Lewis and me write an op-ed and publish it in a Washington State newspaper. Certainly having something in the Bar magazine would be helpful. But we are planning a meeting soon of the task force, and I think it's already been scheduled to discuss rollout and to get ahead of messaging challenges and make sure that we are attending to the public education aspects of this challenge too. But no, but your comment is exactly right on, and it really is one of our next steps that we have to undertake. Thank you very much, Governor.
Thank you.
Governor Dresden.
Thank you. So first of all, I'd just like to echo the sentiments. Tremendous work by the task force. Really impressed by the work product, and really thanks to everyone on the task force for their hard work. I really like the experiential proposals, the alternate proposals. My question is, so insofar as right now the bar exam is the only path toward being or the primary path to being a lawyer in Washington. It's administered by the Bar Association. And so with these two alternatives, 2 and 3, that would be, as I understand it, primarily, if not completely, sort of governed by the law schools. I'm wondering, what sort of role do you see for the Bar Association in overseeing these programs, the curriculum, or otherwise, in terms of as these the people that might choose these pathways proceed toward becoming licensed lawyers in Washington? I'm just sort of wondering, how do you see this entity being involved?
Justice, maybe I could get us started, but I would say that each of the deans of our law schools will have to take a look at our faculty, at our staffing, at our programmatic structures. I am sure that we will be making some changes in preparation for the instantiation of these various pathways in our profession in Washington State. And it is the case already that we depend on many of you to serve as adjunct professors in our law schools. Our students often tell me that it is our adjuncts, it is you, practicing lawyers, who dedicate their time and attention and focus and expertise and wisdom to adjunct teaching, who often provide them the best experiences as part of their legal education. So I have a feeling that with respect to the law school experiential pathway, members of the Washington State Bar are going to be critically important in assessing the competency and guiding those students towards licensure. So that's one very important way. But we are going to have to make some changes. One of them, as you will hear soon from me, is the hiring of a new associate dean for advocacy at Seattle University School of Law. If any of you are interested, please let me know. But that we will need to make changes, staff up, reform, reorganize to meet these new demands for sure, curricular and otherwise. Justice Montoya Lewis, did you have anything to add?
Well, I think one of the things to add is just, let me briefly lay out what our plans are in terms of presenting this to the court. I've had 3 en banc conversations with the court at our regular en banc meetings about what's been going on primarily over the last year with the development of these recommendations. And then we're going to be presenting it to the court in a formal way in October. That presentation will be live streamed over TBW, and that will be kind of the official rollout of these recommendations. The court itself hasn't adopted any of these recommendations. They've simply been kept apprised of what we've been doing in the task force, and in some general way, what the recommendations are going to be. So they're very much looking forward to the recommendations of the task force, and I have every expectation that they will also then provide recommendations and will make changes to what these alternatives are going to be. And conceivably, they could say, no, we like the bar exam as it is, we're going to keep it as it is. I don't necessarily think that's where we're going based on the conversations we've had so far. But they have asked me that very question that you just asked about, what does this look like in terms of oversight, and in terms of what the role of the WSBA is, and so forth. The answer to that is I think we don't anticipate a significant change in what has already been happening, but rather some addition in terms of supervision of this program. But I can't tell you that we've developed that yet, because primarily what we've been looking at is getting these alternatives laid out and then hearing from the court about what they want us to do to move forward. I think that what you're asking about is more about implementation, and to a large extent, we've kind of put that off until we really know what the court itself is going to be willing to adopt in terms of those changes. So I don't have a great answer for that, except to say that it is front and center of our concerns as we move to the implementation, which will have to include additional conversations with the Board of Governors, and the law schools, and so forth. So I think that that's just kind of going to be part of the coming work of the task force, and what we will be looking to you for in terms of recommendations, and what you think the bar can commit to in terms of supporting whatever these alternatives ultimately end up looking like.
Yeah.
And
good.
if I can add on to that a little bit,
Please.
So I think one thing I've learned from this conversation is that I need to highlight this section a little bit better. But one theme you will see throughout this is that it's actually this WSBA taking more control over the licensure of attorneys in Washington, because the truth is right now, 99% of licensure in the state, we defer to NCBE and the American Bar Association. Not that we wouldn't still do some of that deferral in this case. Like, I think a lot of it would still be deferred to the ABA for law school stuff. But in this, you will also see that for like example, in the law school experiential pathway, part of the bar application would be students submitting a portfolio representing work done during their 500 hours as a supervised practicing, law student. So the bar would still have that role, and it would actually have through this proposal a greater role in bringing on and managing the licensure of this state of our students. And I think one thing I'll say kind of broadly too on this, that I think touches on what Justice Montoya Lewis was just saying. One conversation we had a lot around, equity and around these and this as licensure is that we are limited right now in what we can do. And what this does is really creates new opportunities. And in one large area where it creates new opportunities is the opportunities to do more and to take further steps after this. So one thing you'll see in here is the discussion of, you look at lawyers who practice or who pass the bar and then do terribly unqualified things as lawyers. One thing we're looking at in this and hoping to do is begin looking at how we ensure competence over time from lawyers, how we actually build a better profession instead of just marking one point in time and saying you're free and then maybe disbarring you or suspending you later, right? Like that's not a very proactive way of doing this. And so same with, equity. This is not going to solve the equity gaps in this profession by any means. But it does create opportunities, and it creates opportunities for us to do more by pushing out apprenticeship programs to and getting lawyers involved in this and really advocating for lawyers to become part of this program to help in these marginalized communities in this area. So it's,
right.
Yeah, there's a lot of opportunity here, and it does give the state bar more opportunity to take control over who we license and who we're taking responsibility for.
Yeah. Thank you, Jordan. Governor Bloom.
Thank you, Dean Verona and Justice Montoya Lewis. Appreciate the hard work and the efforts that have gone into this process to date. And I thought I'd kind of pick up. To President-elect Abel's point earlier. A lot of times, you're once you're admitted to practice, you're a lawyer, and so some lawyers command higher fees, some command lower fees based on what their expertise and what their background and experience is. And so, although clearly that's kind of a matter to be worked out over time as implementation moves forward, assuming that it moves forward in some form. But one of my thoughts, particularly with regards to the experiential, there was some concern about whether, law firms that have more robust resources and deeper benches may be able to take advantage of the opportunity for lower cost labor, for example, if they or unpaid labor expense or labor, and therefore, potentially exploit applicants to the bar or candidates for the bar. But it seems to me as though, some of the larger legal employers are institutions and corporate. For example, does the Attorney General or the state of Washington hires and employs many lawyers? Would this be something that they would be willing to support? I mean, clearly they have a lot greater resources to be able to, depth of bench for mentors and supervisors and that type of thing. And the federal government as well. For example, Department of Labor or the Internal Revenue Service or different government agencies as well. So, I mean, it seems like there's a lot of different constituencies here that could potentially be tapped into in support of this experiential piece. And I didn't know how, whether those kind of stakeholders or potential stakeholders have been kind of canvassed or brought into the conversation, and how kind of much awareness there is at this point in those other communities. So that's just kind of observations and thoughts, and then kind of a question is with regards to kind of the breadth of knowledge in a greater universe, so to speak.
Governor, thank you very much. Justice, would you like to take that one?
Sure. I think that the fact that this task force exists and what we've been doing is, I think that I've had multiple conversations with lawyers and law firms, but I don't think that this is something that has been sort of rolled out to the public in the way that we will be doing. So I think what you're describing is absolutely important and necessary, but it hasn't really happened yet because there wasn't much to share except the mission of the task force. Now we have more concrete recommendations. So this is the beginning of that process that you're seeing today that we'll be doing with the court. The reason why we're doing it through TVW, it won't just be live streaming that day. The presentation itself will live on a permanent link at TVW. There will be a period of time open for comment and discussion. So that's all to come. And so I anticipate having a clearer plan for laying all of that out. And I share many of the concerns that have been brought up today in terms of all of these issues. I don't think we're going to be able to resolve all of those questions, but I think it's very important that we identify those potential problems so that we're both building them into some of the solutions, as well as being on the lookout for things happening. And then also, I think it's going to be important to build those into whatever studies we're able to fund to look at these cohorts of licensees.
Could I add a note on that again?
Yes, please.
So I also think, we do have to kind of think about what the public is concerned about, whether they're going to be participating in this. But I also think we as lawyers overblow the importance that the public, or overstate in our minds the importance the public sees on the bar exam. I don't think the public really knows much about it or cares about it. And these examples I'll ask you all right now. How many of you in this room know whether your primary care doctor is board certified? It's not a requirement. Many doctors are not board certified. Not all hospital privileges. Yeah. So what I'm saying is there are these things that you may know, you may not know, that don't make that big of a difference. Or even better, because the more real example in this is, how many of you can say when the last time was that the medical licensure system was, when that switched over from being a more knowledge memorization based to more of a practical skills based licensure program for the medical system? Anyone have an idea when that was? All right, we got one person on. Brent is on top of his medical stuff. My point being, though, I think what we're talking about is we're going to, what people will ask is, are you licensed by the state bar? I don't think they will ask, how did you get licensed by the state bar? I think that is really not the concern of people, because what we need to do to establish trust in the public is establish trust in us as the leaders, as the state bar, because that's what people are going to look to. Establish trust in the courts, which our court thankfully has a lot of right now. That's what people are going to care about more so than trust in the system that we use. They want to trust us.
Yeah. I unfortunately have to drop off in about 2 minutes to welcome some judges to our street law training at noon here at Seattle U Law. But I see that we have Governor Tolson and Governor Williams-Ruth. So maybe we could hear from them one after the other. And then I will leave Justice Montoya-Lewis to
I unfortunately have something else at noon myself.
Okay.
So I think
All right. So Governor Tolson.
Well, first of all, thank you, Justice Montoya Lewis and Dean Verona and all the other members of the task force for all this hard work. I had a lot of questions I wanted to ask, but given the time constraints, I just want to ask one, and that is, you mentioned briefly the presentation en banc to the Supreme Court, but what I want to know is when the public is going to get your recommendations so that, you know, people like me can share that information with when your report's going to be final, I guess is what I'm asking.
Great question. Governor Williams-Ruth, and then we'll handle both questions at the same time.
Thank you. And actually, I was just going to be talking about that process, but I'm happy to defer to you.
No, please do.
No, go ahead. Go ahead. You can go.
Okay, so the Jordan and I and Dean Verona and Justice Montoya Lewis will be making our TVW presentation debut in October. I believe it's October 11th.
Mm-hmm.
That is when we will be just rolling it out to anyone who wants to watch TVW. But the process itself is meant to be very much like what we went through in Oregon, where the task force in Oregon submitted to the Oregon Supreme Court the reports that they came up with that were the finalized report. The court said, thank you, we're going to look at these. And then they sent back questions and said, here's your follow-up that we want to know. And then they answered those and they said, great, this is our decision. This is where we're going. Now we want you to go through and create the programs. In fact, they just had their final submission. Let's see, today's Saturday, so on Thursday at 1:00. And the court received it and they basically indicated they're going to be making their final vote on the proposed actual plan 2 years after the report was submitted in November. So that's what we're anticipating is going to be the process here. That these first reports are going to come, they're going to get finalized, they'll be sent to the Supreme Court. The Supreme Court, we then will anticipate there's going to be questions. There may be homework back to us to say, we really want to know what your thoughts were on this. And then they're going to say, we like numbers 1, 3, 5. From character and fitness, we want 1, 7, 9, 10, and nothing else. And then go back and create that next phase of ferreting out the actual program and process. So that is what we are anticipating. So, but Jordan and I and our two co-chairs will be getting our makeup on and doing our TVW debut together on, I think, again, the 11th of October.
Thank you, Brent. All right. Thank you, everyone, so very much. Thank you, Justice Montoya Lewis.
Thank you.
Okay, so with that, we're at lunchtime, and we'll okay. We're until lunch.
If you're on the nomination.